Assalamu alaikum, good evening. Welcome to another edition of Legal Ease, where we try to make the law easy for you, the viewer. This evening we're going to talk about employment law. The law in South Africa governing employment relations is fairly complex. There are different laws governing different aspects of the law. For example, you have the Labor Relations Act that deals with something. You have the Basic Conditions of Employment Act that deals with something else. You've got the Employment Equity Act, then there's health and safety. So there's a variety of laws and acts that deals with employment. This evening I've got a special guest who specializes in labor law and employment law. He's going to be talking to us about employment law. The Basic Conditions of Employment Act is going to feature quite prominently this evening. And our guest this evening is Mr. Mohammed Angamia. Mohammed, welcome, and Jazakallah for making yourself available this evening.
Assalamu alaikum. It's a privilege to be Professor Raja.
Okay, just briefly tell us about yourself so that the viewers know who they're dealing with, because in a while we're going to ask viewers to call in if they have any questions, any comments. A bit of background about yourself.
Okay. Well, my name is Mohammed Angamia. Yeah. I'm an attorney in private practice. The name of my firm is Angamia Attorneys. Okay, we are located in Lenasia and in Parktown. We specialize in civil and criminal law, and with a focus, obviously, on labor law as well. Well, that's basically what we do.
Okay, let's kick off. I mean, obviously the labor legislation in South Africa is vast. We've got the Labor Relations Act, like we said. We've got other laws. But let's talk about the basic, because that impacts on everybody.
Yes.
Small employees, domestic workers, corner cafes, whether it's one person employing one other person, or whether it's a big company, the Basic Conditions of Employment Act. Tell us briefly, what does the Basic Conditions of Employment Act govern?
Yeah, I think it's important for people to familiarize themselves with the Basic Conditions of Employment Act, because it's sort of the default act that governs relations with that governs conditions within the workplace. Okay, it essentially illustrates what sort of conditions one should impose in an employee-employer relationship, and its main obligation is to ensure that everyone's right to fair labor practice is protected according to Section 23 of the Constitution, where everyone has a right to fair labor practice. It's one of their fundamental rights mentioned in the Bill of Rights.
I suppose, as the name is, basic conditions, so it would deal with basic conditions.
The basic conditions.
What are the type of things that it deals with?
It deals with aspects like leave. For instance, different types of leave: family responsibility leave, sick leave, annual leave. It deals with working hours. It deals with whether an employer can deduct from your salary, your notice periods, maternity leave. The very basic very basic conditions, essentially, that one would need in an employment contract. Would be in this act.
So appropriately, this time of the year, a lot of employers, small employers, domestic employers, cafe employers, big employers. Most of the big employers would know about it, but small employers, somebody just starting off, he's not sure. Employee now wants to go on leave because it's December. Most people go on leave on December. And the question is, how much leave is an employee entitled to?
Okay. Annual leave is either 21 consecutive days. Consecutive days would obviously include weekends because it's all consecutive. And if the employee does not want to take 21 days, he could take 15 days, which is ordinary working days leave. Okay. Now that's annual leave. That's for a period of 12 months. Okay. Now if an employee was working for less than 12 months, okay, then leave will be calculated much differently. Okay, in that particular instance, one would look at the amount of days that the employee had worked for. Okay, and the method that we use to calculate leave, according to the Basic Conditions of Employment Act, is 1 day for every 17 days worked, or 1 hour for every 17 hours worked. and that will determine how much leave is accrued to you.
Okay, and the 3 weeks that you're talking about, that would depend on the number of days that an employee works, I would imagine. If an
Yes.
employee works 5 days
Yes.
or 6 days, that would determine how many days, working days, the employee gets.
Yes.
Okay, so if it's 5 days, it'll be 15 days a year. If it's 6 days, it'll be 18 days a year.
Yes. Yes.
Okay, and as you said, if it's 21 consecutive, then you will count the weekends as well.
Then we will count
What
the
about
weekends.
public holidays during the leave days?
Public holidays are not included, and they do not constitute leave days. Public holidays is something that is already due to you, and it would be unfair to count them as leave days for employees.
Okay, because public holidays is a paid
It's a paid
day
it's a
anyway.
paid
You
day.
don't
And
have
if
to
you
work,
work on
you
a
get
public
paid.
holiday, you get double your pay.
So, in other words, if a public holiday falls during your leave period, you must add an extra day for every public
Yes,
holiday.
add an extra
So, for
day.
December, for example, Friday, the 16th is a holiday. If somebody's on leave already, then Friday wouldn't count. The 24th,
Yes.
25th, these are public holidays, they would be added to the
Yeah,
holiday.
public holidays are not
Who is
included.
covered by the basic one? Does it cover everybody?
The Basic Conditions of Employment Act covers most people, okay, but there are certain exclusions.
Right.
Okay, people who work less than 24 hours in a month
Right.
are excluded. Okay,
Okay.
the South African National Defence Force is excluded. The South African National Intelligence Agencies and certain umbrella bodies under them as well are excluded, as well as people unpaid volunteers for charitable organizations.
Okay.
Those are excluded, and independent contractors. Independent contractors.
Okay, so independent contractors, because they're not employees. There's no
They're not-
employer
yeah, they're
employee
not
relation,
regarded
they're
as employees,
independent
yeah.
contractors. Okay, but there's certain conditions in the employer, like overtime work and things like that. How does that work?
Overtime. Overtime must be by agreement.
Okay.
Okay. One cannot force an employee to work overtime. There are specific instances where one includes overtime in their contract, and in that particular instances, there is a possibility that the employee is obligated to work overtime in certain instances where it's mentioned in their contracts. But if it's not mentioned in their contract, they cannot. Overtime is if one works overtime, it cannot be more than 12 hours a day. Okay, that means if you are working, in our law, we have 45 hours a week.
All right.
Ordinary working time is 45 hours a week. Okay, if you are working a 5-day week, then the ordinary working hours is 9 hours a day. Okay, if you are working a 6-day week, then the ordinary working hours for that would be 8 hours a day. Okay.
Because the maximum needs to be 45.
But the maximum needs to be 45 hours, okay? Now, above that, we have overtime, okay? Now, overtime cannot exceed 12 hours a day. So if you are working a 5-day week and you work 9 hours a day, it cannot exceed 3 hours on that day, okay? For that day. And for the week, your overtime cannot exceed 10 hours. Okay, so if you add all the overtime hours, it cannot exceed
So maximum
10
10 hours a week.
Maximum 10 hours a week.
Okay. We sometimes hear managers say, we don't get overtime, we have to work all the time. Why is that?
Yeah.
Senior managers.
Senior managers are excluded from overtime. Okay, because of their seniority, they obviously earn a very high salary as well, and they're in charge of the company, and because of their obligations, they need to avail themselves, at odd times. Okay. Also, people who regulate their own working hours, such as salespeople, for example, salespeople on the road, sales reps. They also don't fall within the overtime category because they regulate their own hours.
Okay. There's an earnings threshold.
There is an earning threshold also. The earning threshold is, I think, 205,433 rand and 30 cents.
Okay.
And if you earn that salary or above, then you also don't qualify for any overtime
Okay,
pay.
so over 200, just over 200,
Just over
205, 400
200,000.
and something annually, if you earn that, the overtime doesn't apply to you.
Overtime does not apply to you.
But they can work you
unfortunately.
then sort of 12, 24 hours a day. Surely they need to take into consider health and safety, family responsibility.
Yes. Employees must be given a rest of at least 12 hours after work, from the time they knock off until the next day.
Okay, so that's important.
That is important. They must be given 12 hours a day.
And would this apply to everybody? Corner cafe owner, domestic workers, factory workers, anybody earning below that threshold?
Yes.
Okay.
Yes. It can be reduced if in writing
Yeah.
to 10 hours.
Right.
But there must be consensus between the parties.
Okay. So
There
that
must
by
be-
agreement.
By agreement. Yeah. If you want to reduce something, and the basic conditions of Employment Act, the employee cannot impose any obligations that are less favorable in terms of the act. Okay, but if it's more favorable, then they can do it. So it sets the minimum standard that is required within the workplace.
Okay, so what you're saying, by contract you can improve on the working conditions, but you
Yes.
can't make it less favorable.
Yes, yeah. For instance, maternity leave.
Yeah.
Okay, maternity leave is unpaid. Okay, according to the basic conditions of Employment Act. However, a lot of corporate companies pay for maternity leave. Okay, and in that particular instance, that would be more favorable for the employee. And that's just one of the examples.
Okay.
And also, like they offer, certain companies offer study leave, which is also not offered in terms of the Act. So that would also be something that is more favorable to the employee.
I think that's important because a lot of people at this time of the year are thinking, oh, maybe next year I need to study.
Yes.
I need to approach my employer. Am I entitled to study leave? Some people I know get study leave. But you're saying the basic conditions of Employment Act doesn't make provision for study leave.
No. Study leave is not made. There's no provision for
So that's
study
an
leave.
added benefit provided by the employer through contract.
Yes, that's a good employer.
Yeah. Okay. Yeah. Because through the contract, you can contract out of the act. That's what you're saying, provided it's more favorable. not less
Provided that it is more favorable.
Okay. And then other things like meal breaks. Is it necessary to have a meal break, or can you say, work your 8 hours and then go home?
You see, in that particular instance, the basic conditions of Employment Act says that meal breaks, there should be a 60-minute meal break after every 5 hours of work. Okay? And that meal break is unpaid. Okay, it doesn't constitute
So
hours
that's not
of
part
work.
of the working hours.
Yeah, it doesn't constitute your working hours. The meal break can be reduced. Okay, obviously, if you want to reduce it, there must be consensus again between the employer and the employee. Okay, so you can reduce it to 30 minutes only.
But you can't do away with it completely.
You can't do away with it completely, unless there is a provision where if the employee works for 6 hours, okay, and also this must be done by agreement, you can do away with the lunch break. Okay, if he works for 6 hours only.
Okay, so up to 5 hours. If he works 5 hours, he must have an hour's break. If by agreement it could be reduced to half an hour, that's what you're saying. If he works up to 6 hours, you can do away with that lunch break. But not if he works more than 6 hours. Works up to 6 hours,
Yes.
by agreement, the lunch break can be
The
done
lunch
away
breaks
with.
can be done away with.
Okay. And I assume, why would you reduce it to half an hour? Would be the other half an hour for tea breaks or something to that?
Yeah, I mean, yeah, they could use the half an hour, the other half an hour for tea breaks. I mean, tea breaks is something that's not generally dealt with in the Act itself.
Okay, so that's not provided for.
That's
in the
not
Act.
provided for in the Act. If your company offers you tea breaks, then good for you.
So that will be because some companies may have an hour's break and
Yes.
then additional tea breaks.
Yes.
And
A
I
lot of
assume they won't. That would be part of their working hours as well. Or would it depend on the employer? I suppose?
That would depend on the employer. That's with regard to tea breaks.
Okay, and then you said 5-day week, 6-day week. We sometimes get companies working 7 days a week. They open on Sundays. Big supermarkets. Now coming towards Christmas, even places like the Oriental Plaza, for example, they said they're going to be open on Sunday. They're going to be open on Friday, which is a public holiday. Can you have people working 7 days a week every day?
Well, I mean, you can't have people working every week, 7 days a week. Okay, but there are certain times where where they can work on Sundays and on Saturdays. If one were to work on, let's say, a public holiday, then obviously you get double pay for the public holiday. If you work on a Sunday, and if the Sunday is not an ordinary working day for you, okay, and like when we say not an ordinary working day, like your business is not generally open on a Sunday, okay, and in that particular instance, you get paid double as well. If you're working overtime, then it's 1.5, not double.
All right.
Okay, so some people think that you get paid double when you work overtime, but it's not true. You get paid 1.5 unless your employment contract states that you get paid double.
Okay. So it's again the contract can improve on the basis.
The
Okay,
contract
maybe an
improves.
appropriate time to take a break. Viewers, we'll take a short break. Please stay with us. Come back after the break, and we'll continue. Inshallah. Assalamu alaikum, good evening, welcome back. We're busy discussing employment law. Our guest this evening, Mr. Mohammed Angamia. As we stopped for the break, we were talking about Sunday and public holiday leave. Mohammed, we were talking about Sunday holiday, and I mean Sunday being a holiday, but people can work, they get paid double. How does rest periods fit into this thing? Because surely people need to rest. They can't go on working and working without any rest.
With regard to rest periods, one has to have a 12-hour rest period daily, okay? So after work, you need to have a 12-hour rest period.
Okay, so from the time you stop work till the next day
Till the
when you
next
start,
day.
there must be a 12-hour.
There must be a 12-hour rest period. And then weekly, there must be a 36-hour rest period. Okay, so you can't just expect employees to work like machines. They also need to recuperate.
Okay, so that would mean maximum 6 hours, 6 days a week. You can't work 7 days a week. But as you said earlier, occasionally you work on a Sunday.
Occasionally you work on a Sunday.
But that would be special circumstances.
Those are in those particular circumstances. The Act makes provision for certain instances where employees can agree to work on that Sunday, okay, and they can reduce their weekend period to I think it's about 8 hours, and then they can get the next weekend off.
Oh, okay.
Yeah.
So they can get other days off.
Yeah.
There's other leave. There's things like sick leave. Employees get sick. Tell us a bit about sick leave. How much sick leave is an employee entitled to? And is that paid sick leave, unpaid? How does that work?
Sick leave is calculated according to a 3-year cycle. Okay, unless you are an employee working just for 6 months or under, then you get 1 day of sick leave for every 26 days worked.
Okay.
Okay, and if you're working for more than that, then the cycle will start. Okay, now with the cycle, sick leave is calculated according to the number of days you would work in a 6-week period. Okay, so let's say for instance you are an employee that works a 5-day week. Okay, so that's 5 days a week. Okay, so within a 6-week period you would have worked 30 days. Okay, so in that particular instance you would get 30 days of sick leave within that 3-year period. Okay, and obviously it would apply differently if you worked a 6-day week, and then you calculate it accordingly, and that would be about 36 days.
Okay, so sick leave is 3-year cycle. It's paid sick leave.
It's paid. Sick leave is paid.
Yeah.
Okay. However, you must prove your illness. You can't people can't just stay absent.
Okay, so they have to bring medical certificates.
If someone is absent just for 1 day,
because sometimes you get the flu just for 1 day, genuine flu in the middle of the week.
It's not necessary for them to bring a medical certificate if they're absent for 1 day, unless it's a common occurrence. Okay, and in that particular instance, the employer has every right to go and ask you, for the proof of illness.
Yeah.
Okay, but if it's more than 1 day, then you should bring your proof of illness to your employer if it's requested.
What about if somebody's away every Monday, for example, Saturday, Sunday they
Yeah.
don't work, Friday they sick, or Monday they sick?
In that particular instance, it would be reasonable for an employer to ask for proof
Yeah.
as to why you were absent. In
So a
that
medical
particular instance,
certificate
your
would be
medical
required.
certificate, and also it's important, to also for employers to also implement policies in their company, where if an employee is absent on a Monday or on a Monday on a Monday or maybe after a long weekend, etc., then they should bring some sort of proof proving their absence.
What happens if an employee exhausts his sick leave? Because sometimes people are really sick.
Yeah.
6 weeks over a 3-year period, employee has used up the 6 weeks. What happens there?
In that particular instance, it would be unpaid leave.
So the basic conditions does make provision for
Yes.
unpaid leave in the case where
Yes.
somebody's exhausted. their sick
Yes,
leave period.
it's unfortunately the employee is sick,
Yeah.
but he's exhausted all of his sick leave that is available to him, so it would be unpaid leave.
Because the employer wouldn't be allowed to dismiss that employee.
No, the employer wouldn't be allowed to dismiss him because he's got a valid and reasonable excuse for his absence. However, the employee will not be paid for those absence.
Okay. Then there's other things like maternity leave you spoke about, where 4 months unpaid leave. But what does the employee do? What does she do during that 4 months if she doesn't have an income?
For maternity leave, which is unpaid generally, okay, and if you find yourself working at a company where you don't get any paid leave for maternity leave, then you can go to the you can claim from the UIF, the Unemployment Insurance Fund, and they will assist you, in that particular instance where you would receive some sort of funding from.
Okay, so UIF benefits for
Yes.
maternity leave, that's possible. I suppose you have to apply in time. You have to show, obviously, that you did give birth
Yes.
and all those type of things. And then family responsibility. Baby's going to get sick, funerals. There is a thing like family responsibility, I believe. How does that work? How many days is that?
For family responsibility, employees who are entitled to family responsibility leave must work for a minimum of 4 months within that particular business or company, and for a minimum of 4 days a week in those 4 months. Okay, then you are entitled to 3 days of family responsibility leave. Okay, family responsibility leave is leave that one takes when their child is born, when their child is sick, when your grandparent, your parent, your sibling, your spouse, your adoptive parent, your adoptive sibling is, they pass away.
Okay,
and in that particular instance, the Act makes provision for you to, to tend to whatever personal things you may do.
So in the event of a death of immediate family member,
immediate
you're
family member.
entitled,
If your cousin or uncle dies, the family responsibility leave does not apply.
Okay, although we think our cousins are
Yes.
family,
Yes.
direct family, immediate family, but the law doesn't
unfortunately, the
recognize
law doesn't recognize that.
it. Okay. And you said it's 3 days, paid
It's
family
3
responsibility.
Yeah, 3 days paid family
Can
responsibility.
you accumulate it? If you didn't take it this year, can you take 6 days next year?
No, you cannot. It doesn't accumulate, unfortunately.
Okay.
Unfortunately. Also on the topic of leave accumulating, if your annual leave accumulates, and there's a certain period within which it may be forfeited, and usually 6 months after the leave accumulates, it would be forfeited. So you can't just let your leave accrue. You must take your leave. Employees shouldn't just work all the time. They need to take their leave, otherwise it'll be forfeited.
Okay, so but the employer, I suppose, must insist that employees take it.
Yes.
Because it's in their interest.
It is in
Employees
their
need
interest.
rest. Okay. Then, how would employees know? I see lots of times you work into an organization and there's on the wall they've got charts, dealing with the law, Basic Conditions of Employment Act. That's a requirement, is it?
That's a requirement in terms of the Act. In terms of the Act, all employees should be well aware of their rights in the workplace, okay? And it should be in a language in which they can understand, okay? So one has to place the Basic Conditions of Employment Act, in an area where all employees have access to the Act and they know what their rights and obligations are in terms of the law.
Okay. Something important we haven't spoken about, and I mean, a lot of people often wonder this, and sometimes people don't do it. Contracts, the employment contract.
Yes.
That is a requirement, I'm sure, in terms of the law.
In terms of the law, a contract is required, but it doesn't have to be a written contract per se. The employment contracts, in order for a contract to come into existence, there need to be an offer and an acceptance. Okay, the offer is made by the employer, okay, and then the employee accepts the offer, and then there's an employment relationship between the two. And that's where it begins, okay? And they may agree to certain terms and conditions verbally, and in that particular instance, most of the terms and conditions will be governed by the Basic Conditions of Employment Act. It would be incorporated into their contract. Okay. Now this is where having a written contract is always more feasible. Okay, because in the event of a dispute with regard to the terms and conditions of a contract, one can always refer back to a written contract and see exactly this and see exactly what was agreed upon between the parties. However, with a verbal contract, one doesn't have that opportunity. So, that just leaves the space open for dispute.
Okay, so it's a good idea to have it in writing, because in the event of a dispute, you could always refer to that. That's perhaps a good time for us to take a break. Let's take our viewers, we'll take a short break. After the break, we'll come back, inshallah, and we'll continue talking to them. After the break, we'll also invite you to call in with your comments and questions. So please stand ready with your phone calls. Call in, ask Mohammed any of your questions related to employment law. Assalamu alaikum, good evening, welcome back. Our guest this evening, Mohammed Angamia. We're talking about employment law. Just before the break, we were talking, Mohammed, about contracts, the importance of contracts. You mentioned that contracts doesn't have to be in writing. What should an employer do to safeguard themselves, to safeguard the employee? Because, as you said, in the event of a dispute, if it's in writing, then obviously you can show what the agreement was.
The employer should mention the conditions of service in writing. Okay. Also, the specific role that the employee will play in the company. Okay, because sometimes employers change positions of employees, and in that particular instance, the position won't be a substantial change; it will be a minor change. And the employee might think that the employer is changing his his whole function at the company. And in that particular instance, if you have an employment contract in place, that can resolve all of these sort of difficulties.
Okay, because you can always refer to the contract.
You can always refer to the contract.
Conditions of service are.
Yes.
Okay. And then family responsibility leave. We know that you said that's 3. Does that apply to everybody?
Domestic workers are allowed 5 days family responsibility leave in terms of the sectoral determination.
Okay, and sectoral determination, we had discussed sectoral determination previously, and that's something that the Minister has the power, the Minister of Labour, to make a sectoral determination.
The Minister of Labour makes the sectoral determinations, and that's how it comes into effect.
Okay. And that varies the domestic workers' conditions of service. It may improve it, for example, like you say, 5 days instead of 3 days family responsibility leave.
Yeah, and that's just applicable to domestic workers, no other worker.
And it's the sectoral determination that determines minimum wage for domestic workers as
Yes, yes.
well. Okay. Then viewers, just a reminder that please call in if you have any questions, any queries. We'll ask our technicians to put, there the number is, I was about to ask them to put it on the screen, the number 011 086 7777. Please call in if you have any questions referring to employment law, if you have any questions referring to the Basic Conditions of Employment Act. We've got Mohammed Ngamia here. He's ready to answer your questions. Or if you have any comments that you want to add, any of your experiences that you want to add. Okay, we've got a caller on the line. Assalamu alaikum.
Good afternoon.
Good afternoon.
Good evening, sorry.
Well, good evening. Okay.
A question for the attorney there.
Yes, go ahead.
If, in terms of the test, the temporary employment services conditions, when you actually do your employment equity reports to EA2 and EA4 under the Employment Equity Act, where do you put the temporary employees? Do you put them for the client or do you put them under your reporting? Because the Act says in Section 57, if the employees are more than 3 months, they're deemed to be the employees of the client. I'll listen on the TV. Thank you.
Okay, Mohammed, perhaps not quite the Basic Conditions of Employment Act, but please go ahead. Employment Equity Act
Not quite the Basic Conditions of Employment Act. Professor, I think this is something that your expertise could maybe answer.
Okay, the Employment Equity Act makes provision for that, and I assume you're talking about reporting annually, what you need to report. The Employment Equity Act makes provision for companies that, for example, have more than 50 employees or their earning capacity is more than a certain amount. Those companies need to report on all employees that are working for them, and it depends on this temporary employee. Are you talking about a contract employee? Is the employee of the primary employer, or is the employee just on contract employed by the service provider? If by the service provider, then clearly the service provider needs to record that employee on their books. Mohammed, if we can go on, callers, please call in 011 086 7777. And viewers, to be fair to Mohammed, okay, Assalamu alaikum, another caller.
Wa alaikum.
Wa alaikum salam. Could you just talk more clearly into the phone, please? Okay, it seems like we lost you. Please call in again. Something went wrong with that call, but please call in again. And please, to be fair to Mohammed, could we avoid questions about the Employment Equity Act? Could we keep it to the Basic Conditions of Employment Act? You're welcome to ask about the Labor Relations Act. Okay, we've got another call on the line. Assalamu alaikum. Good evening.
Good evening.
Go ahead with your question.
I want to ask Mr. Mohammed concerning contract.
Okay.
I did work for company for past 8 years, so give me a contract, I love the contract, and they upgrade a new contract for me.
Right.
So when I was going to pay my provision fund, because I didn't have the original contract for the past 6 years, so they're not going to pay. So what must I do with that?
Okay.
Your line is very bad.
The line is not very clear. We can't quite. Could you talk into the phone more clearly and repeat your question, please?
Okay. I work for a company for the past 8 years, so
8 years.
Okay.
I was weekly, they upgrade me to monthly, they give me a contract.
Okay, can I just stop you? You've been working for the company for the past 3 years, did you say, or 8 years?
8 years.
8 years.
Yeah.
Okay, and you had a fixed term contract for 8 years.
Yeah, 6-term contract. I lost the original one from the beginning, so they upgrade my contract, but it didn't start from the beginning.
Okay.
But 2 years, so 6 years they give me a contract, I lost it. So they upgrade me for monthly. Later they give me a new contract for 2 years,
Okay.
which they upgrade. So when I left the company, they said because I don't have the old contract, they can't pay me a provision fund. They have to pay just for the one I had the contract with for 2 years. So what must I do with it?
In other words, they can't pay you for the full time that you were working for them.
Yeah. Yeah.
Okay, Labor Relations Act, Basic Conditions of Employment Act also determines how you calculate years of service.
Is this for severance pay?
Okay, were you retrenched? Okay, he's gone. So maybe we should ask, let's talk about it. In the case of a retrenchment.
In the case of a retrenchment, okay, then you would be entitled to severance pay.
Right.
And severance pay is calculated as one week of pay for every year work. Okay, so if he worked for 8 consecutive years at this company, then he would be entitled to eight weeks of severance pay in this particular instance.
Okay, so viewer, in this case, you had your previous contract, you then had a following contract. If your break in service was for less than 12 months, then that would be calculated as your years of service, and you must be paid for every year, not just for the last 2 years or the last 3 years contract. But now the employee is only paid for what can the employee do in a case like this? But I suppose this is not Basic Conditions, the Labor Relations Act.
Yeah, this is part of labor relations.
Okay.
The employee could either refer it to the relevant bargaining council,
Right.
or the CCMA.
Okay.
And they will come to a determination, and they will handle the matter.
Okay, if an employee doesn't know where to go to, obviously first stop CCMA, go to the CCMA, file a case of
Yes.
severance pay not being paid. The CCMA would then appoint a commissioner.
Yes, the CCMA would then appoint a commissioner, and they would determine, they would make an award either either against him or for him, depending on the facts of the matter.
Right. Okay, another caller on the line. Assalamu alaikum. Assalamu alaikum. Go ahead with your question.
Walaikum assalam. My question for the attorney tonight. I'm not too sure if it falls within the ambit of the BCEA.
Okay.
However, my situation is as follows. I've been employed at a company for 3 months.
All right.
And it's a service business, so whatever services I provide, they remunerate me. However, they keep a certain percentage due to the fact that I use their name and their bank account, etc. On the first month, my services were quite good, and we had a good relationship and financial. However, on the second month, they called me in to say they want to increase their percentage to 40%. And I find this unfair, and what do I do?
Okay, just clarity. Are you an employee or are you an independent contractor? Are you working on a salary or only a commission type of thing?
It's only on commission, so I'm not too sure.
It's only on commission. Did you sign any contract?
It was just a verbal agreement that I will be contacted to them. This is the services I provide, and this is the work, or rather the remuneration they will offer me.
Is this the only company that you work for?
That's correct.
And you devote all your time to this company?
Are
you allowed to work for any other company besides this company?
No indication from their side.
I mean, you could argue that he could be an employee of the company. Obviously, it would depend. We would need more facts from the company's side as well. But if he is regarded as an employee for this company, then what the company has done is that they've changed the terms and conditions of the contract unilaterally, which is not allowed. And you can go and refer this to the CCMA as an unfair labor practice, and they can make a determination regarding this.
Is my first point of contact necessarily the CCMA, as I don't want to upset the relationship between the employer and myself?
Your first point of contact should be the employer. If you have a human resources department, you should contact the human resources department and lay a grievance. And if that fails, then you could contact the CCMA.
Okay, thank you.
Okay,
very
so
much
file a grievance in the organization, as Mohammed says. File a grievance because the CCMA is always going to say, did you exhaust internal processes? So file a grievance. If that doesn't work, and the grievance has several steps, you take it all the way to the top. If that doesn't work, you then declare a dispute and you refer it externally to the CCMA.
Thank you very much. I appreciate your help. May the Almighty reward you abundantly.
You're welcome. And be clear, you need to determine whether you're an employee or an independent contractor. Mohammed, as an independent contractor, there could be a breach of contract.
There could be, but that's a civil case.
Because then it's not a labor matter.
That is not a labor matter. That would be a civil matter.
Okay.
You cannot take that to the CCMA.
So if this person files a grievance, that doesn't work, goes to the CCMA. If the CCMA determines that there's no employment relationship, then what the person needs to do is go externally.
Yes, then you need to go to a lawyer, and he will advise you accordingly on what to do, because it becomes a civil matter.
Okay. So then common law contract comes into
Common law contract.
Okay,
Common
excellent.
law contract.
Okay, employees have been working for a long time. Do you have to keep records? Does the law require you to keep records of employees?
Yes, the law does require you to keep a record. Employers need to keep records of their employees for 3 years. Okay, in terms of the Basic Conditions of Employment Act. The records of the company should include, their names, the reason why they were dismissed, the position at their companies. If they were under 18, then also their date of birth. That's basically what the records have to, and any other further particulars, like their IDs, etc. And whatever information you have on the employee, should be kept in their files.
Okay, appropriate time for another break, our last ad break before we end the program, but please viewers be ready with your phone calls, call in, and inshallah after the break we'll continue. Any questions you have for Mohammed on the Basic Conditions of Employment Act preferably, and Labour Relations Act, if you have questions about employer-employee disputes, if you have questions about contracts, I'm sure Mohammed will be happy to answer that as well. So inshallah after the break, call in. Viewers, Assalamu alaikum. Welcome back. Our guest this evening, Mr. Mohammed Angamia. We're talking about employment law, the Basic Conditions of Employment Act in particular, but as well as the Labour Relations Act. And if you have questions about contract law, Mohammed will be happy to answer that. So please call in, make comments, whatever. Mohammed, there's a few things we still haven't talked about. Sometimes employers want to deduct money from an employee's salary. Is an employer allowed to deduct employees from an employee's salary? How much is an employer allowed to deduct?
The general rule is employers are not allowed to deduct unless there are certain circumstances which arise. Obviously, they need consensus from the employee. Okay, that's one of the circumstances. Okay, another one would be if the employer has to deduct in terms of a court order or a garnish order which was granted. Okay, then the employer is obligated to comply with that order. Okay, or an arbitration award, for instance, from the CCMA or from a bargaining council. The employer would have to comply with the deduction in that particular instances. Deductions cannot be more than 1/3 of an employee's salary. Okay, because the employee needs some money to live as well. So you can't just, deduct 3/4 of his salary and then give him 1/4 of his salary and expect him to live off that money. The Basic Conditions of Employment Act makes provision for, a reasonable deduction from an employee's salary.
Okay, but certain things I suppose the employer don't need permission. Income tax, for example, pay as you earn.
Yes.
Those type of things.
For those type of things, you don't need deductions. That's part that would be included in the contract. Okay.
So normally, if you want to deduct, you need the employee's permission. But there's certain deductions, like the statutory deductions, you don't need permission. Okay. If an employer wants to terminate an employee's contract in terms of the Basic Conditions of Employment Act, Labour Relations Act, we know there must be a valid reason. You can't just, but the Basic Conditions of Employment Act makes provision for termination. What is the notice periods? And how is that calculated?
For termination, if an employee has been working for less than 6 months, okay, then he has to give 1 week's notice for his termination. Okay. Or also, if the employer wants to dismiss the employee, he'll give 1 week notice. If the employee has been working for more than 6 months but less than a year, then 2 weeks notice. Okay, and if an employee has been working for a year, then it's 4 weeks notice, which is a month's notice. And everyone knows the general notice period to be a month's notice. However, this doesn't apply to domestic workers. If a domestic worker has been working for more than 6 months, then she still gets 4 months. She's getting 4 weeks notice.
Right. And that's again because of the sectoral determination.
Yes, that's because of the sectoral determination.
Viewers, the number is on the screen. If you need to call in, 011-086-7777. We are talking to Mr. Mohammed Angamia. Any of your questions, any of your comments? We're almost coming to the end. Mohammed, we've spoken about all types of things. We've spoken about meal intervals. We've spoken about rest periods. We talk about leave, annual leave, sick leave, maternity leave, family responsibility leave, keeping employee records. We've spoken about deductions, what you can, what you cannot deduct, termination of employment. Now, yes, you can give notice to terminate, but there's restrictions in terms of the Labour Relations Act. You can't just terminate.
Yes, you can't just terminate.
Yeah.
If an employee just decides to leave work,
Yeah.
and not fulfill their notice period, then the employer can take civil recourse against him, because then in that particular instance, the employee would be liable for his salary amount to the employer. Okay. However, if the employer does not want to fulfill his notice period, and he can approach the employer, and he can offer his salary, the amount of his salary for that in lieu of that notice period.
Okay. And if an employer terminates, the employer, as you said, has to give the 4 weeks notice.
Yes.
Does the employer have to allow the employee to work that 4 weeks, or can the employer say, I'll pay you for the 4 weeks and leave immediately?
The employer can do that.
Right.
The employer can say, I'll pay you for the 4 weeks and you can leave immediately.
Okay,
But
we've got
it
a
must
caller
be-
on the line, Mohammed. Assalamu alaikum.
Assalamu alaikum. My name is Fatima.
Fatima, go ahead with your question.
My question is, how valid is a verbal contract to a supervisor in a building?
Okay, not a labor question, but a contract question. And I did say you can ask contract question.
Any contract, whether verbally or written down, is a valid contract. Okay, but in order to prove that contract, you would need a specific amount of proof.
Okay.
So if you have, let's say a witness who was present during that consultation, or if someone recorded it, maybe someone was in the room with you, in that particular instance, you'll need some sort of backing if there's a dispute about the verbal contract.
No, there isn't. I'm just asking this question on behalf of somebody in our building, but I think that your explanation is clear enough. So
Okay.
shukran for that.
Okay.
Okay, so
Assalamu alaikum.
wa alaikum salam. Jazakallah for your question. Okay, so it's clear, as you mentioned earlier, and now it becomes even clear, there's a verbal contract. A verbal contract is valid. The difficulty comes in proving what the terms of the
The
contract
difficulty comes in
are.
proving.
And therefore you need to have contracts in writing.
It's always better to have it in writing.
Yeah.
Speak to your supervisors by email.
Okay, and that would sort of, or confirm what the contract
Yes.
was by email.
Yes.
That's a good idea.
That's a good idea.
Okay. Enter
Yeah.
into a verbal contract, follow it up with an email and say, this is what we agreed on, and keep that as a record. That would serve as proof.
Definitely.
Okay. Mohammed, we just about to finish the program, and obviously, is there any last minute thing you need to tell the viewers about?
I think there's a lot of people who are going to begin their new year signing employment contracts. Just make sure that you check every term and condition of the contract before you actually put your signature onto that contract. And it's very important, because a lot of the times we miss the fine print So just make sure you read all your contracts.
Okay,
before
Mohammed,
signing.
Jazakallah for having come on this program. I'm sure the viewers learned quite a lot. Viewers, Jazakallah for being with us, and inshallah we'll be back next week with another session of Legal Ease and the week thereafter. So join us again. Assalamu alaikum wa rahmatullahi wa barakatuh.
Assalamu alaikum.